Uh, as y'all find your seats, it is now. Whoop. Wait for everybody to settle. Thank you. As y'all find your seats, it is my pleasure now to introduce our first plenary session titled Title IX, Gender Identity and So Much More. The Biden-Harris regulations have forced gender identity into the conversation about Title IX. Their rule, which has been enjoined in 26 states and counting, has ramifications for free speech, religious freedom, due process, and parental rights. Please welcome our moderator, Mark Chenoweth, president of the New Civil Liberties Alliance, who will introduce our panelists.
Thank you very much. I will introduce the panelists in the order in which they are going to be presenting. So starting with Candace Jackson. Candace is an attorney who served as acting assistant secretary for civil rights and deputy general counsel in the U.S. Department of Education from 2017 to 2021, where she was responsible for drafting the first ever regulations under Title IX addressing campus sexual harassment and assault. Candace has returned to private law practice, where she's a partner at Jackson & Bone, LLP, and has represented incarcerated women in California prisons in Wolf's lawsuit to overturn the 2021 law that allows male criminals to choose to be housed in women's prisons based on gender identity. To Candace's left, we have Scott Schneider. Scott is the owner and founder of Schneider Education and Employment Law and has advised companies and educational institutions nationwide on a variety of complex legal issues with a focus on particularly sensitive matters like institutional response to sexual misconduct. Prior to founding his own firm, Scott was an equity partner in two major national law firms and served as in-house counsel for Tulane University. He's a prominent litigator as well as a sought-after advisor on Title IX, labor and employment law issues, and various risk management concerns. He has led numerous investigations of serial sex abuse allegations, allegations of misconduct involving senior leadership, and other acts of institutional misconduct. He's also handled various high-profile program reviews of institutional response to sexual misconduct, racial discrimination, athletics department ethics, and compliance and treatment of at-risk employees and students, and has done training on those issues as well. To his left, we have Professor Casey Johnson, who's a professor of history at Brooklyn College and the Cooney Graduate Center, where he's taught since 1999. Casey has written 13 books on topics in U.S. political history, U.S. foreign policy, and legal and policy debates surrounding campus due process and civil liberties. Perhaps most famously, his Duke lacrosse case blog, Durham in Wonderland, was named ABA Journal's Best Ethics blog in 2007, and he continues to blog on higher ed matters in the blog Minding the Campus. On my far left, which I have never had an opportunity to say before, so I thought I would do so here, I have Congresswoman Harriet Hageman. Harriet represents the state of Wyoming in the U.S. House of Representatives. She grew up on a ranch, attended Casper College on a livestock judging scholarship, and earned both her bachelor's degree and law degree from the University of Wyoming. A litigator for 34 years, including a few years at the New Civil Liberties Alliance. Harriet is nationally known for challenging federal overreach, for protecting water and property rights, for exposing federal land and wildlife mismanagement, and for fighting back against the unconstitutional and unlawful acts of unelected bureaucrats, including those at the Department of Education. Harriet did some Title IX litigation for us. So Harriet has extensive experience engaging in complex trials against federal agencies and has been admitted to practice in several states as well as the United States Supreme Court. I think you're all in for a real treat with this panel, and so with that, Candace, I'll turn it over to you to sort of set the scene here.
Sure, thanks, Mark. Well, as a kind of overview then to set the tone for the panel, I thought I would go way back in history, way back to 2017, and think about why,
That was a lifetime.
why it wasn't it though? Why we spent a lot of time and energy in the Department of Education under Secretary DeVos issuing Title IX regulations at all, and the central problems that we were trying to address at that point, which culminated in the 2020 regulations, did center around allegations on campuses of sexual harassment and sexual assault, and then specifically what we heard time and time again was these types of allegations have high stakes for everyone involved, and schools are not getting it right a lot of the time. Schools are overreacting or underreacting. It was one or the other. Civil liberties that schools should be accustomed to following and know that they have to follow, like due process, like freedom of speech and First Amendment protections, we were hearing time and time again and seeing more and more evidence that over the prior 5 to 10 years, schools were just too often tossing out those civil liberties with tunnel vision on just reacting to the politicized problem of sexual allegations. So we took care to try to issue regulations that didn't just say to schools, do better, respect the First Amendment, respect fair process and due process. We went ahead and spelled it out. And a lot of people got upset about how prescriptive that spelling out was. But that's why we did it, was because schools told us, frankly, and showed in their history of trying to determine the facts in campus tribunals around sexual allegations, that they didn't really know. They didn't really know what it meant to try to do both, to try to take sexual harassment allegations seriously and yet never deprive someone who's accused of a fair process, and never use sexual harassment as a way of shutting down freedom of speech, which is more critical in an educational context than just about anywhere else, including workplaces, et cetera. So fast forward then to the Biden-Harris administration and sitting on the 2020 regulations, let's think about the problems that they wanted to solve. Right, that's right. Our regulations did not yet give biological men and boys the right to pretend to be girls. So that's the problem they solved. And they did a good job solving it, because not only did they bring in the term gender identity into Title IX regulations for the first time ever, without any kind of definition to that term, but they went a step further, and they not only said that Title IX now prohibits discrimination based on gender identity, they spelled out what discrimination means in the context of gender identity. And this is very unique compared to other characteristics like sex, like pregnancy, et cetera. With respect to gender identity, the new regulation actually spelled out that it causes more than de minimis harm and therefore is a Title IX violation not to accommodate a student, not to allow a student to participate in an education program or activity consistent with the student's gender identity. So it goes a step beyond non-discrimination in a traditional sense, and in my view crosses the line over into outright requiring accommodation or validation of a belief, as opposed to just saying, well, somebody with this belief shouldn't be treated punitively. Don't kick somebody off of their sports team just because they have a gender identity belief about themselves. That could have been tolerable, perhaps, in the law. But instead, they go one step further, and they say it's illegal discrimination based on gender identity, not to validate someone's gender identity. So that's the state of where the Biden-Harris Department of Education left Title IX things. As it was already mentioned, thankfully, lots of groups jumped in right away, and 26 states have obtained injunctions against this. So we shall see going forward, but that's my opening statement, and look forward to panel discussion.
Terrific. Scott?
I blame Richard Nixon. He was the one that signed Title IX into law, although I don't think anyone at the time understood the significance of what was being agreed to in 1972. Let me give you just kind of a little history. I'll go back even further. 72.
Further than 2017?
Yes. 72 is my birth date, too, so I'm very old.
Don't say that. That's my year of birth, too.
Yeah, okay. Well, I feel old. I'll put it that way. What's interesting about Title IX was from roughly 1972 until the Obama administration, you didn't have a whole lot of enforcement. All of the enforcement you did have came from litigation. And in fact, I mean, the whole private right of action, which is an implied right of action under Title IX, if you listen to the oral arguments, it's in a case called Cannon versus the University of Chicago. The primary argument was we need a private right of action because OCR in its then form, and this was before the Department of Education, isn't enforcing it. So we need to be able to sue. And I fast forward, I thought the conversation earlier was interesting. I want to fast forward then to the Obama administration. I was at Tulane at that time. We still had Title IX. If I walked on a university campus anywhere in this country and I asked the question, who is your Title IX coordinator? Nobody would have known, okay? If I asked this question, so I do a lot of training, try to be very even-handed about it, but I did this one training for the University of Texas system around Title IX and Title IX obligations. And 400 people are in the audience. And I asked the question, how many of you all were in doing this work prior to 2011? And 3 hands went up. And so it was enormously, I've described it as, under the Obama administration, enormously effective advocacy work that was done to get the attention of universities, colleges and universities around this issue, and a whole bureaucracy has grown from that in a cottage industry of lawyers and consultants and all of that sort of stuff. I will say this on the 2020 regs, and I may be getting ahead of myself. We were seeing not only sort of the blow up internally of staff, but also, and Casey has done, frankly, a fantastic job of chronicling this, an unprecedented increase in the amount of student-initiated litigation against universities, challenging the decisions of institutions, and a willingness by courts to come in and say, we're not giving you any deference here. We're going to second-guess your decision-making here. So there was a flood of respondent litigation. Fast forward to the Trump administration. They said, hey, we're going to make this a priority. We think due process rights have been stomped on. And at some schools, at least if I read your Twitter post accurately, in some of the cases, that probably was the case. One of the things I'll just tell you as a lawyer who works with institutions of very different means, very small institutions, religious institutions, big publics, well-heeled privates, one of the requirements in the Trump regulations was that everybody is entitled to a full-blown hearing in certain Title IX connected cases. And I said to myself, at some of these schools, this is going to be a complete disaster. And whether it was because of COVID allowed us to sort of gradually get into it or something else, in fact, it's worked. I feel like the Trump era regs, as much as at the time I thought, I'm not sure this is going to work, and oh, by the way, this is enormously prescriptive. It's telling every institution in the country, no matter what the resources are, this is the one and only way to do it. I thought this is going to be a disaster. And in fact, I think, and I'm curious if you feel the same way, it's turned the temperature down considerably. Certainly in the litigation space, we're not seeing as much litigation, and if you comply with the 2020 regs, courts, I'm in Texas, I litigate with Judge O'Connor and Judge Kaczmarek and have lost and won. But if you're complying with the regs, you're in a pretty good spot. It's also driven a lot of things that were being handled through the single investigator model to something called informal resolution, which I think, honestly, has served students particularly well as opposed to going through an adversarial process. I fast forward to the Biden administration, and I have to be honest with you, there was a part of me that said, wow, this is working. What the heck are we doing here? And so, there's another change of regs. What I can tell you, I take the institutional perspective is, tell us what the rules are, be really clear about what the rules are, and don't change them every 4 to 8 years, because that is a recipe for disaster. And so that's my perspective, and I look forward to being on this panel.
Casey?
So to some extent, I'm going to follow up on what Scott said, and certainly we have seen fewer litigation by accused students since. And one of the striking things to me about the lawsuits that we've seen filed by states against the current Biden administration regulations is that it's been almost all gender identity, except for Judge Kosmanik's case, which had some due process elements. But even though it's been gender identity that's been the core aspect, to me the most interesting thing about the current regulations, and frankly, to me the biggest policy change, was the rollback of the due process concerns. Most colleges and universities already have very, very liberal policies on gender identity questions, so I'm really not sure how much the regulations at a policy level will change things. By contrast, the new regulations on due process will have enormous changes. So for those of you who don't follow the stuff all that closely, the key procedural protections that were given to all accused students in Title IX cases as a result of the regulations that Candace helped push forward were the right to a live hearing, the right to cross-examination, the elimination of this single investigator model where there'd be one person who would investigate the entire thing. And also critically a right to access the evidence that the college gathered in the investigation. The case would begin with a written notice of allegation, and the complainant had to file a written notice. So in the Biden, Catherine Lehman, who's the current OCR head regulations, all of those rights have been eliminated.
And she was the OCR head under
And she was
Obama too, right?
the second OCR head. And it's true that this is an issue that's been somewhat politicized. Democrats have tended to be more pro-complainant rights. Republicans have tended to be more in favor of due process. But this is also an area, I think, where Biden getting the nomination for 2020 really did make a difference. Among leading Democrats, Biden cares about this issue. He was the person who was pushing the complainant rights perspective in the Obama administration more so than any other policymaker. I did a FOIA of the Dear Colleague letter approaches, and one of the things that I found remarkable was there was almost no involvement in the Dear Colleague letter from Obama White House staffers. It was Biden's vice presidential office that was really pushing this. So once Biden comes in, and once he reappoints Lehman to the position, we kind of knew where this was going, regardless of whether these things were going to work or not. That said, I think there are a couple of interesting elements, one of which explains why the administration has fared so poorly in the litigation, and the second, I think, may cause problems for colleges down the road. I'd be interested to hear more from Scott on this. The first is that the key issue for the due process side of the regulations here was not whether or not you should have a live hearing or a cross-examination. That already had been decided by the DeVos regulations. It was, should these procedural protections now be revoked? And that was not really a question that the Biden people dealt with either in the NPRM or in the preamble to the current regulations. They just sort of assumed that we were back in 2011 when there was no law on this issue at all. And there were comments that were offered, including by groups of lawyers that represent accused students, and the administration basically blew off these comments. And the same thing happened on the gender identity front. And one of the things you see constantly in these decisions where the administration so far has lost is a sense from courts that the administration really wasn't following the spirit of the APA when it pushed through the rules, that it was soliciting comments, but it wasn't really responding to the comments in any meaningful way. It already had decided what it was going to do, and I think it had. As soon as Catherine Lehman was appointed, everyone knew what we were going to get in terms of the final regulations. And then the second thing, and this is more looking forward, the administration is really inviting colleges to walk into a legal buzzsaw. Yes. They want to move back to 2011, with the Dear Colleague letter and with this real push to stress complainant rights education. At that point, there had been one federal appeals court that had ruled for an accused student in this really, really weird case in the Second Circuit that's unlike any other case that I've ever seen in this area. Now there's been positive rulings for accused students in every appellate court except for the 4th and 11th Circuits. And so universities are now being pressured by the federal government, look, do more with complainant rights, but they're facing a legal environment in which courts have really asked some hard questions. And so I think if I were in the general counsel's office for a university now, I'd be sort of closing my eyes, because it's going to be a very, very difficult position for them legally moving forward, at least in the states that don't have those injunctions. And one final point, these injunctions are not just 26 states. One of the injunctions out of Kansas also applies to a whole bunch of universities outside of the 26 states that had a student member in one of the organizations that sued. So we now have this patchwork situation of Title IX enforcement where you could be in a university in the same state or even in the same city, but with completely different rules. And most parents don't go to college checking out disciplinary procedures. So this is just a recipe for confusion moving forward. Thanks.
Terrific. Harriet, if I remember correctly, you were in secondary school when Title IX came down, so you really experienced the before and the after personally.
Well, and that's what I was going to talk about. I did practice law for a long time, but I'd like to really focus on kind of the practical aspects of Title IX and my own personal experience. So in 1972, when Title IX was passed, I would have been 10 years old. I was in fifth grade. But when I went into junior high, and I'm from Wyoming, least populated state in the nation, and so I went to a very tiny school called Fort Laramie. It was Lingo Fort Laramie. I grew up on a ranch outside of that town. And, my class was 25, 30 students, but when we went into junior high, there was really only one type of athletics for girls, and that was volleyball. There wasn't anything else, but my class happened to be full of very athletic girls, and so we went to the administration and asked for track and basketball, and then we started asking for a lot of other things as well, such as having the ability to take shop classes and engage in livestock judging and do different things. And so my experience has been that Title IX actually worked from a practical standpoint, even in small schools out in the middle of nowhere. Just from the standpoint, because I don't think that Title IX is complicated. I think that when you read it, people understood in 1972 what it meant, and they understand today what it means. And the administration worked with us, our principal, our superintendent, our teachers. We found coaches, we got uniforms. We did what we needed to do, and throughout both junior high as well as high school, participating in basketball, track. I was a long-distance runner. But one of the things that was very important for me was being able to expand into some of the non-traditional types of classes that I took. I obviously was taking the European literature and calculus and trigonometry, but I was also taking shop. I was also learning how to weld. I was also learning how to do woodworking and doing a lot of the things that most girls didn't do. And then when I went to college, I was one of the very first girls in the United States who got a livestock judging scholarship and went to Casper College and judged livestock throughout the United States. Now that might seem like kind of a funny history or something that's insignificant, but in reality, I think livestock judging is one of the reasons why I've been as successful as I have, simply because of the skills that it teaches. So my experience with Title IX has always been very positive. And again, I look at it from a very practical standpoint of what people understood it to mean. It has become complicated because the courts and schools and regulations and things, regulators and the administration has stepped in, as starting with the Dear Colleague letter in 2010, and made it very complicated when I don't think that it was ever intended to be, and I don't think that it needed to be. From the standpoint of a member of Congress, however, this to me is a classic example of Congress saying one thing and then regulators and bureaucrats coming in and saying something entirely different or rewriting it. Title IX is how many words? 37 words or something like that. And how many thousands upon tens of thousands of words have been written attempting to interpret it. It doesn't need to be complicated. If Congress intended to have boys playing girl sports and we wanted to redefine sex, we can redefine sex. But we should not be allowing unelected bureaucrats to do that. And so while working at NCLA, I had the opportunity to challenge some of these things, not just with Title IX, but other areas as well. But again, I think that this is just the classic example of whether it is a civil rights statute or it is the Clean Water Act or the Clean Air Act or whatever it may be, of Congress saying one thing and the unelected bureaucrats and the executive branch coming in with an agenda and fundamentally changing the meaning of that statute to pursue a political agenda. And I think that that's what we really have to focus on. The change with Chevron deference, that the Supreme Court decision there, I think is going to be huge in this area, because there will not be the deference to the schools or to the Department of Education in terms of defining these terms. Obviously, we know that the Supreme Court will weigh in on this at some point with a substantive decision as to what is meant by the word sex. And I hope that they do the right thing. I hope that they will preserve Title IX as it was intended to be. We'll see if that's ultimately what happens. But that's just kind of the perspective from a practical standpoint, both as someone who benefited from Title IX as well as someone who's in Congress and gets very frustrated when the Department of Education or the Department of Energy rewrites what we do for purposes of pursuing a political agenda. So like everyone else, I look forward to engaging with the discussion.
We'll certainly want to give the panelists opportunity to ask questions of each other, but Candace, maybe I'll start with a question for you. What about this idea that these new Title IX regs seem to have turned Title IX on its head, whereas it was, as Congresswoman Hagan was just talking about, it was created to help women. Now it seems like it's being interpreted to have boys play and girls sports in a way that takes opportunities for participation as well as opportunities for scholarships away from young women.
Well, and I think it's even worse than that, because it's at a conceptual level that it's doing this. If I asked, what for a decent definition of gender identity, I think it's difficult, and these regs don't provide one either. But whatever it means by groups that use it without irony, it seems to be purely subjective. And if you're going to put a characteristic called gender identity that relies on each person's individual, subjective, personal declaration about themselves, but that declaration is directly relating to a characteristic that used to be considered objective, sex. And now we're going to,
Number of
so it's not,
chromosomes.
so this gender
Or which
identity
kind of chromosomes,
characteristic isn't independent of this characteristic that we've been protecting for 50 years that used to be just taken as an objective fact. It's very interdependent on it, interrelated with it. In fact, you can't really honor the concept of gender identity without erasing the meaning in a legal category of sex, because you can't have both together and honor both at the same time, or say we're going to enforce something based on both of these characteristics. You can't do that just purely logically. And so gender identity tends to push sex out of the way altogether. So it's not just the discrete problems of scholarships and opportunities and teams and resources that girls and women will lose out on because things that were supposed to be dedicated for girls and women are now open to boys and men. But it's worse than that, because it's really not even allowing girls and women under Title IX anymore to be recognized legally as a class, distinct from men and boys. So even if somebody came forward on a straight up sexual harassment situation, let's say, the way that it would be recorded now would be based on everybody's gender identity. It wouldn't be, I was assaulted by a man. I'm a woman, I was assaulted by a man on campus here. It would be, well, the student identifies as a woman, the student, how do you identify as? I mean, it's all subjective in every context like that girls and women are experiencing on campus.
So in some of these harassment or assault cases, the underlying facts are being distorted is a
Yes.
good word, yeah.
And we're seeing that in criminal court situations already, where gender identity has slid in. A woman's right to name a male rapist is being infringed in courts, and so the Title IX tribunals are going to be following suit, and it's hard to see that as any kind of advancement or empowerment for girls and young women in schools, not even being able to just say what happened to them if they come forward with a sexual abuse claim.
Harriet, you mentioned the Chevron deference and the demise of Chevron deference, and I wanted to ask you about gender identity in that context. 37 words or whatever it is in Title IX, and now you have all of these regulations that are seeming to go in a very different direction than what Congress may have had in mind in 1972. Is that something that the Department of Education has any chance, assuming that Harris wins in November or something, and so that they're continuing, not to put a pall on the conversation, but and so that they're continuing to defend these regs in the next administration. Is there any chance post-Chevron that this kind of interpretation of Title IX can survive?
I don't think that it can. I just think we have to get back to common sense. Listening to Candace talk, that's exactly right. We are distorting and we are bastardizing the English language in order to try to accept something that every one of us in our own mind know isn't correct. If you watch the Olympics, I'd never in my life imagined that I would watch an Olympic sport of men kicking the hell out of women. I'm sorry. I'm stunned that we are at the point where we have an Olympic sport of men beating up women and both taking the gold medal. Those two men have birth defects, but it didn't make them women. And I think that we have to be honest about what it is that we're talking about, and we have to get back to the common sense. And if they do not defer to an interpretation of sex as it may be defined, again, by bureaucrats today versus what was meant in 1972, the 1972 Title IX was clearly intended to even the playing field for girls and women. It wasn't for any other purpose. There may be other laws, in fact, there are a lot of laws that may have a broad variety of purposes. Title IX had one purpose, and that was to even the playing field for men and women. It was to ensure that women had the ability to engage in sports, to make sure that women had the ability to become livestock judges if they wanted to. It made sure that women could not be denied admission to law school based upon their sex. When you look at the very foundational purpose of Title IX, it was not to protect any other class of people. It was to protect one class of people, and that is women. And the only way that they can continue to use Title IX and distort it the way that they do is if they misinterpret and redefine what the word sex means and the very purpose of Title IX.
Can I riff on deference for a little while? Is that okay?
Yeah.
Riff on deference. What's interesting, and I'm thinking about what Ilya was talking about earlier, what's really interesting about this is, again, prior to 2011, Title IX's been on the books since '72. I was at Tulane in 2011. We didn't spend a ton of time on Title IX compliance. I'm just going to be honest with you. Like, what changed? Was it a change in the law? No. Was it a change in regulations? No. An administrative agency issued something called a Dear Colleague letter, and everybody kind of went nuts.
A form of guidance.
Yeah.
I guess, I don't know.
Sub-regulatory.
It's like, Dear Colleague, and if anything is ever a misnomer, it's that. It's like, we're going to tell you exactly what to do, and you stink, and we hate you, and all that sort of stuff. And so one of the interesting things, and I give you
Only
all,
slightly better than my esteemed colleague that we hear sometimes on the floor of the House.
there's a lot of passive aggressive in faculty. But I give you all credit for saying, hey, if we're going to do this, we're going to go through the process of actually writing regs. And say what you want about the Biden regulations, at least they went through that process. And so I just wanted to point that out. Everything, this whole bureaucracy that we were talking about during the last session that grew on college campuses and continues to grow, and has spawned a cottage industry of hearing officers and decision makers and advisors for respondents and complainants, pretty much comes from a Dear Colleague letter issued by the Department of Education in 2011.
Yes.
But also a Dear Colleague letter that the figures that wrote and issued the letter fully expected colleges and universities to follow. So it wasn't as if this was some sort of accident where the Obama people released this and colleges somehow overreacted. The very aggressive action of colleges was what the Obama bureaucrats wanted to happen.
Let me tell you, I want to echo that just for a second. So in addition to the 2011 Dear Colleague letter, they issued this list of shame and all this sort of stuff. All these schools are under active investigation. So I'm at Tulane at the time, and do you all know Scott Cowan? He was the president at Tulane, fantastic university president, rebuilt Tulane after Hurricane Katrina. He would send me to faculty senate meetings. He must have hated me. So it's like nerdier than a Star Trek convention and less consequential. Sorry to say that. Does that hurt you as a faculty member? It's true. So I'm walking back, and I'm in Gibson. Oh, good. Thank you. I was going to do the Trump, turn down the lights. I'm walking back, and Scott's there waiting for me, and he says, I'm seeing all these newspaper articles about schools on this list of shame. If that ever, this wasn't exactly what he said, if that ever happens to us, you're going to be out of a job, okay? That's not how he put it. And what I had to explain to Scott was, in these cases, 100% of the time, at least 50% of the people are upset with the end result, all right? I'm either finding someone responsible for sexual misconduct which isn't warmly received, or I'm not, which isn't warmly received, okay? And that person, under the Obama administration, could go to the Department of Education. The Department of Education would then open up a broad-scale program compliance review, which there are still hundreds still open right now at the Department of Education, and then blast you on the list of shame. So I just wanted to give that perspective as well.
Scott, in our pre-discussions on this topic, you had mentioned an example, and maybe you can't say this publicly, so I don't mean to put you on the spot, but where there's one of these that was open for a long time that they just tried to revive.
Yeah, so this was about 3 months ago. I represent this small private university. Fortunately, we're in Texas, and they had an OCR complaint that was opened up in 2015, which was a lifetime ago, right? And I don't hear anything from the Department of Education for 9 years. And then out of nowhere, like at the end of the semester where everything's going crazy in my world, they reach out and they say, hey, we want 10 years of disciplinary records going back from 2000, and it was basically 1997 to 2007. I said, I think you all have lost your minds. Yeah. Don't you all have enough to do? You have a flood of Title VI related complaints that you're not processing, gender equity complaints on athletics. And long story short, I said, I am ready to go to court. Unfortunately, I'm in a jurisdiction where I have, judges who aren't very receptive to the Department of Education and seek an injunction. And they did back off, but that was a very recent experience.
And if they're doing it to one college, chances are they're doing it to other colleges who maybe didn't get them to back off.
Yeah, the older I get, the grayer the beard gets, and the meaner I get with federal regulators. So maybe they get a nicer one who's not as mean.
Candace, Scott's comment brings to mind the fact that the really guidance was all there was from about, 1975 or something. I forget, there was a series of regulations in the 70s, or maybe one set of regulations.
Yeah.
And then nothing until the ones that you wrote, right?
Well, there were some
a lot of
single-sex education regs that came out. So there were some, but very sporadic. There never was anything on sexual harassment or sexual violence of any kind like that. Never anything in regulation that helped explain to a school when it comes to any kind of punishment, here's what you got to do to comply with the Constitution. Very, very sparse.
So one question I have, getting back to the Chevron deference point, does the demise of Chevron deference, will that encourage the agency to do more in the way of regulation, or will it encourage it to do more in the way of guidance? Or do you think it won't have an effect on that decision?
Depends on who's in charge, right? Because I think but for the DeVos commitment to regulating as opposed to, hey, let's just turn this around and reverse everything that we want to by another letter, I think but for that, Biden-Harris administration would not have bothered regulating. They just would have issued their Dear Colleague letters and started enforcement actions in the direction they wanted to, like they did in the Obama administration. So now that that's become a recent trend, hopefully at least the department, before issuing new directives, would bother to regulate on it. It certainly would absolutely change the mindset in going about doing that. The 2020 regulations came under attack in numerous lawsuits right away by groups that hated the new regulations, didn't want the due process, didn't want the fixed definition of what sex-based harassment means so that you don't infringe on speech, didn't want any of the procedures in place. And the regulations were upheld time and time again against injunction challenges like that. One teeny part was struck down by a federal court judge. But for the most part, they stayed up. How that would have turned out if deference was the issue like it is today, I honestly don't know. We might have been at a little bit more risk because they were pretty prescriptive. So it would change the mindset, I think, of how an agency should take care to go about issuing regulations and what the rationale for it is, yeah.
Casey or Scott, you talked about how the schools were eager to go along with what the Dear Colleague letter was asking them to do. I wonder if you have a comparative for us. Were they as eager to go along with the DeVos regulations as they were with the Dear Colleague letter? After all, the DeVos regulations are actual law that's binding, and the Dear Colleague letter is guidance, which is not legally binding. But I'm just wondering, can you give us a comparison, or did they sort of go along with both, or was there more reticence? Or
I mean, I'll chip in. There was no eagerness on my end to go along with the 2011 Dear Colleague letter, I'll say that. We had Catherine Lehman on our campus around that time, and any suggestion now that she was concerned about due process then is just not accurate. And that was very clear to me. And we said, we have some concerns about this. When the 2020 regs came out, I think there was some, how do we do this? Because keep in mind, we're talking about some of these schools that really small, and now you're saying, hey, you need to do a full-blown investigation, a full-blown hearing where you have attorneys who are providing cross-examination and all that sort of stuff. How do we do this in a way to make it work? Some schools just throw money at it. You hire, like I get brought in occasionally to be a hearing officer. You pay me money, I'll do a good job. But they don't have those sort of resources. So no, the answer is I haven't seen any sort of reluctance, at least at the administrative level, to comply with those regs. What I want, and I think what every school wants, is give us some rules and keep the rules in place and stop changing them every 4 to 8 years. I mean, that's where mistakes happen. I mean, you change rules, mistakes, even under the most well-intentioned administrations happen. I will say at the faculty level, which is different from the administration level, there was a push to get in compliance with the 2011 Dear Colleague letter and a lot of advocacy and some resistance on the 2020 Trump regs. But at the administrative level, tell us what the rules are. We're going to do our best to comply with the rules.
And I think here also I think that's absolutely true on the administrative side, but there's a difference also, this ties into a point that Ilya was making earlier, between elite universities and everyone else. And we're even seeing this now in the very brief period that the Biden regulations have been in effect. So I'm from Maine. So our sort of preeminent colleges are Colby, Bates, and Bowdoin. Bowdoin is still subject to the 2020 regulations because they're covered by this weird injunction that I was mentioning out of Kansas. So in Bowdoin, in a Title IX case right now, there's an investigation, there's a live hearing, both parties get access to all the evidence, there's cross-examination through an advisor, everything that we've had in the last 4 years still exists. At Colby, which is not subject to the injunction, they've gone back to a single investigator model, full stop. So there's no hearing. They hire one person, the person speaks to the parties and then renders a decision. And Bates, it's sort of in the middle. There's an investigation, and then there's what they call a decision maker who is separate from the investigator, but there's not a hearing anymore. They call it a meeting. The decision maker meets individually with each of the parties. And so I think what we've seen in this is sort of what we saw between 2011 and 2020, that the most intense opposition to procedural fairness in this area tends to come from more elite institutions. And, we've seen this in other areas as well. But it was striking to me how schools, even in this very brief period where there's all this legal uncertainty, race to get away from the procedural protections. And it's just like, you're asking for a lawsuit if you in the future, but they were I think in most of these cases, the schools were facing internal pressures, often from faculty or from activist student groups to move back to the Obama procedures as quickly as they could.
If I may just weigh in very quickly on that, I think that what you're describing and what my experience has been in being an attorney in this area is that the Dear Colleague letter and the push from the administration forced schools to do things that they're not equipped to do. And that's really what ended up happening when you talk about, it's hard enough to get judges sometimes to understand the full concept of due process, let alone when you've got this single investigator model and you're talking to the accused and the accuser and trying to render a decision. What I found in this area is that schools and colleges and high schools, they are simply not equipped to act in these capacities, and I think that that's what the Dear Colleague letter was forcing them to do, and that's why you saw the blatant violations of due process that we have.
And I think this case might have been before you joined NCLA, Harriet, but we represented a professor at a small private college in the Midwest, I think that's generic enough, who the single investigator model at that particular university, the investigator was the women's basketball coach. And that's not to take anything away from the women's basketball coach. I'm sure she's good at coaching women's basketball. But a Title IX investigator who's supposed to be honoring someone's constitutional rights, I'm a little skeptical that that's somebody who's the best positioned person to do that. So.
Yeah, can I just on that? I don't see, this is where maybe you and I part company a little bit. I think the single investigator model can work, but it really depends on having a really good person as the single investigator.
Right.
So this was a long time ago, and I tell the story, and this was in the public domain. I got hired by a big university to investigate a sex assault complaint against a basketball coach. And I had this initial meeting with the complainant, and all this is in the public domain, it's not privileged or anything. I'm like, holy moly, this is a terrible situation. It's a high-profile coach. And the more you started digging into it, the more it became really obvious that it was contrived. And I had just ironclad evidence that one of the witnesses who corroborated the alleged assault was in a different state. And I got the opportunity to confront him with it. And so I issued a report. And I said, not only is he not responsible, all of this is contrived. The person made this up. And it's one of the few cases that I know of. It led to a criminal prosecution of her and the boyfriend who was egging it on. And so that coach got, I think, a lot of due process in that case, and it was a single investigator model. I will also say this. I've done a lot of these high-profile reviews. I hate them. And I got off Twitter because of one in particular. But after I issued that report, and it was like a 30-page report, and I basically said, didn't happen, and in fact, this person's making it up, I got death threats. There's clearly in the whatever culture wars, there's a group of people that if you ever come back and say, this isn't true, and oh, by the way, it's made up, you got to be prepared to deal with the fallout. And so what you don't want as your single investigator is one of those folks or the other person who says they're always made up. You have to look at the facts, go through the facts and evaluate. People do get sexually assaulted. People lie about accuse people of sexual assault when it didn't happen. And so vetting the facts. So it really is I don't have an issue with single investigator. It's the quality of the single investigator.
Was there a single investigator in Durham, North Carolina, Casey?
This is one of the remarkable things about the La Crosse case is that we've been talking historically here. This is 2006, 2007, which after all is not all that long ago. And
Right,
yet
it
there
seems
was
like it.
no thought at all, none, from anyone, as far as I can remember in this case, that suggested this should also be a Title IX case. And if this happened 5 years later, it almost certainly would have been, without question,
Yep.
parallel a Title IX case and a criminal case. And the thing is, if this had been a Title IX case at Duke, which was not a due process-friendly institution, these guys would have been found guilty and expelled in 30 minutes. I mean, it would not have been a quick sort of thing.
They believe
And
in Duke process.
They
It's a
would
very
have
different
got,
thing.
but it is a reminder of how quickly, and this ties into what the Congresswoman was saying, how quickly things have shifted here. This was the highest of high-profile campus sexual assault cases, and even among the most extreme defenders of the accuser in that case, I can't recall a single person even mentioning Title IX. It's quite extraordinary. It is.
No, that is interesting. Harriet, I wanted to, actually, one other question, then I'm going to come to Harriet on something, but you were talking about the divide between elite and, do we say less elite, the colleges, in how these Title IX regs are applied. Is there also a distinction between public colleges and private colleges? And if so, how does that break down?
I think probably so. I mean, I teach at CUNY. CUNY has retained basically the entirety of the DeVos system with regards to procedural protections, even though we're not subject to the Kansas injunction. And that's because, we do have to constitutionally give a degree of due process to our students that, meaning in a breach of contract case at a private institution, there may be somewhat comparable approaches. But yes, I do think that that a student at a public university has due process rights, at least in most circuits, and has a degree more protection.
Yeah, and the Purdue case in the Seventh Circuit was written by Amy Coney Barrett, right? So I think there's some feeling that there's a backstop there at the Supreme Court that if this issue ever does get up there, that constitutional sort of protections, at least for what the Confrontation Clause might be found by the Supreme Court. Sure like to see that happen sooner rather than later. So Harry, my question for you was going to be coming back to the gender identity thing for just a minute. I meant to ask this before. The sort of rules that have emanated from the Biden administration on this topic, could they command, in your opinion, could they command a majority in the House or the Senate?
No.
Good.
Is that a
No.
problem for self-government, that these rules are being put out anyway?
Yeah, well, I think that's why they are. Because you're not going to, this is a 75-80% issue, right or left. People do not believe that men ought to be playing in girls' sports. They just don't. And I whatever the psychology of that's an entirely separate issue. We have done a bill, and I did the debate during the Judiciary Committee markup and hearing on it, to try to protect girls, amateur athletics and the Olympics, to prevent boys and men from being able to compete against girls and women. And we had a 3-hour debate. And I was really the only one on the Republican side that was debating, and I had the full panoply of the Democrats on the other side. And I mean, it got extremely emotional. There was a lot of angst in there, and I just held my ground. But the public does not agree with this at all. And I just do not believe that you could get the regulations through Congress. You just couldn't.
I suspect that might be the case, which not unique to the Department of Education, but we see that across the administrative state, that these things are done by bureaucrats that not only did Congress not do it, Congress wouldn't do it if given the opportunity to do it. And that's why judges, I think, need to be a little braver in pushing back against some of these kinds of things.
Can I chime in on,
Please.
so the intersection between the gender identity problem, as it's written up right now under Title IX, and due process protections. So the due process protections, logically, common sense, they're important, right? Especially in situations where it's important to find out factually if somebody did the bad thing that they're being accused of. When you focus on what the gender identity non-discrimination mandate is now requiring of students and teachers and faculty and administrators, everyone affiliated with education, It's no longer easy to say that someone accused of sex-based or here gender identity-based discrimination or verbal harassment, let's say, it's not easy to conclude that person is being accused of something inherently wrongful, because it could be something as simple as identifying or stating someone's sex. This is a boy, that's why I don't want him in my locker room. Well, a girl making that complaint right now could herself be prosecuted under Title IX on campus, have a complaint filed against her for having displayed discrimination and hostility and potentially harassment against the boy. So due process protections in that kind of scenario don't save anybody, right? Because it's not a matter of finding out what the truth factually was. She said what she said, but she had every right to say it. It was simply a factual statement. And so this gender identity notion is sweeping now under the definition of wrongful conduct, things that amount to no more than expressing a fact or at most an opinion.
Well, that brings up the free speech topic, which we haven't really broached yet, but both with your example and with the use of pronouns, I think you're seeing that come up in some of these cases. How do the new regulations treat free speech, or are they protective of free speech? Are they violative of free speech? How do we see that playing out, both in the regulations and in any litigation decisions that have come down?
Well, the preamble of the new regulations are helpful to tell schools, be sure to interpret and apply all of this without violating the First Amendment, but there's nothing about how to do that. So with respect to...
So good luck.
Yeah, so I suppose it depends on how a school is bound and determined to interpret things, but the department's emphasis is certainly on validating gender identity, even in the realm of speech and thought. If you're not honoring somebody's preferred pronouns, then you are not allowing them to access their educational opportunities consistent with their gender identity.
Yeah, and there is some litigation that's come, compelled speech cases, and on you have to use the preferred pronouns. I think the courts have, in the handful of cases that I'm aware of, sided with the professor who's been disciplined on free speech, because compelled speech in particular is not viewed upon favorably. I will say this.
Especially if they're willing to use the student's name, right?
Yeah, that's exactly right. Yeah, exactly right. Some reasonable, accommodation, to borrow ADA language. I think the free speech issue is enormously interesting in the Title VI national origin, anti-Israel, Gaza protest issue. And I'll just say this. I was at a conference with Catherine Lehman, again, the head of OCR, under the Biden administration. And she says, there is no tension between anti-discrimination requirements and free speech. And I go, that is absolutely wrong. I mean, one of the most, there's a lot of fascinating legal areas in higher ed. I love the stuff going on in athletics. But the tension between, I think it's fantastic. The tension between First Amendment rights, and I'm as pro-Israel probably as anybody in this room, and I get a little uncomfortable sometimes at maybe some of the things that are being done to crack down and some of the things that aren't being done to protect Jewish students. But there's clear tensions between all of those obligations. And the fact that I think you have somebody in the administration that doesn't even acknowledge that, and it sort of is mind-boggling to me. And I'll just give an example. The question about river to the sea, is that hate speech? Well, that violates our anti-discrimination policy. Well, I don't know. It's not something I would utter. Does it trigger Title VI obligations? I don't think it does, but there is certainly a contingent within the Department of Education that thinks it does. Does that student have, especially at a public institution, some First Amendment right around political issues to speak freely in a way that's free from discipline? Absolutely. So there's clear tension. And I'm gobsmacked by the fact that this current Department of Education doesn't even acknowledge it. And it plays itself out, I think, in the Title IX regs, certainly in the pronoun cases, that it's kind of a throwaway. do this in a way that complies with the First Amendment. Well, what if there's tension? There is no tension. I go, okay, well, that's one way to deal with it.
Is that part of the invitation to walk into a legal buzzsaw that you were talking about earlier?
Yeah, that's exactly it. Thank God there are all these legal buzzsaws. My kids, they're very expensive.
And there is in this area, it's an interesting case, which probably some of you know about, that came out of the First Circuit. It's a public school case rather than a college case, where a student at a school in Massachusetts wore a T-shirt saying that there are two genders and was disciplined by the school, and so then returned the next day with a T-shirt saying there are redacted genders, and also got disciplined by the school. And the First Circuit just upheld this the discipline, and that was sort of the opposite of the pronoun case, which was it was in the Sixth Circuit, which upheld the rights of the professors. But it's clear. I mean, there obviously is tension here, and this goes back to Lehman's first run at OCR, where the gender identity question really wasn't on the table. Then obviously Israel-Palestine wasn't on the table then. But there were this extremely broad definition of sexual harassment that she was using. And they were pushing this resolution agreement with the University of Montana, which FIRE was able to block, in part through congressional investigation where Senator McCain came out against it. And at that point they said, well, it's no longer a blueprint at all. But this was this Orwellian plan where they would keep records of discrimination, of speech discrimination cases in the student's file, even if they weren't investigating. It's like, this is obviously not where you want to go at a public university. So I think this has been a practice of Lehman, and I'm also very strongly pro-Israel, but the idea of sending students to Catherine Lehman for assistance in this just struck me as not a good idea, period.
We're going to open it up for audience questions in about 5 minutes, so be thinking about questions that you have. Casey, I think it might have been you earlier who made the point that there's a difference between sort of writing on a blank slate and then writing regulations where you're revoking procedural protections that had been put in place by the regulations that Candace wrote. How is that playing out in either the litigation or in how the regulations are being received, or is there something more you wanted to say on that? I thought that was a fascinating point that was made earlier.
Yeah, I mean, I think I enjoyed Congressman Hagan's remarks just because that they gave, I thought, the common understanding of Title IX, which is that for close to 50 years, this was a law, however you thought about it, that expanded rights. The idea was to constantly expand rights. And that, to me, that's what the 2020 regulations did. After all, they gave rights to both parties. Both parties had the right to access to evidence. I mean, there was just a new case out of the Sixth Circuit from the University of Kentucky where the case went on forever because the university constantly was screwing up, and this harmed both parties. And it was the complainant in that case who wound up suing. And so the pattern always was to expand. Here what you had was a revocation of rights. I mean, there's no other way to describe the due process sections other than that they took away the right to a hearing. And what was striking, and maybe that's a good idea and maybe that's a bad idea. I mean, obviously it doesn't take a genius to figure out what my position on this is. But what was remarkable to me about how the department handled it was that they didn't seem to view this at all. It was almost as if they were pretending that these 2020 regulations didn't exist and students didn't already have these rights. And none of the litigation so far has kind of dealt with this question, but I was struck by the degree to which judges were unwilling to give deference to the department on the gender identity question, because it seemed also as if they just weren't engaging with arguments at all. And that, right or left, that strikes me as a bad idea. When you have an education department that just ignores the spirit of the APA, and I think that's what we saw with these regs.
Yeah. We had talked a little bit about litigation updates. I just want, if there are any other cases that any of you wanted to give an update on or talk about, I wanted to give you an opportunity to do that before throwing it open to questions from the audience. Are there any recent updates anybody wanted to provide?
The Sixth Circuit has scheduled oral argument for October 30th in the challenge, so that looks like it's going to be the first appellate court with an oral argument.
Yeah, I think that one of the real interesting issues going on, and this is playing out on the West Coast in Oregon, is around the new athletics model about, hey, we're going to directly share revenue with student athletes. And I think the latest numbers I saw in NIL, 95% of that money is going to male student athletes. And what are the Title IX implications of that? That's something I work with a lot of schools on. I think that'll be a really fertile ground for future litigation in the athletics space. As we get to a model that compensates student athletes the way we compensate coaches, what are the Title IX implications of that?
Just have about 25% of the male athletes identify as women, and then your stats will be even. It'll be all good.
Well, what about that, Candace? The fact that you see so many boys who want to play in girls' sports, but you don't see, at least, I don't think you see any more girls or women who want to play in boys or men's sports than you were seeing before
Right,
this
not
kind
because
of
of gender identity.
transition.
Right.
Yeah.
Yeah, I think that's true. I think it's not reciprocal at all. The benefits that can flow from adopting an opposite sex identity are not even between men and women at all.
So are we creating an incentive?
Yes,
with
absolutely.
regulations?
Absolutely. It's creating an incentive for men and boys to find a way to, I'm going to say dominate, because when it comes to sports, it's hard to see it any other way. Records, titles, championships, etc.
You haven't seen me play sports.
Not all men. No, but actually just the idea of statistics is interesting too, because you can't keep track of, well, what is the parity level? What is the proportionality going on currently between men and women, between males and females with regard to anything, whether it's name, image, likeness money, or faculty promotions, or anything else where we've tried over time to track any disparity and then figure out, is that disparity okay? Is it down to discrimination? Do we need to do anything about it? But at least we have the statistic there, the data.
Right.
And it does not take very much fudging the data, swapping sex categories to really truly skew the true picture or perception of whether there is or is not some kind of disparity in what you're looking at, sex-based disparity.
That's actually, I mean, it's a really interesting point. I don't like weighing in on the gender identity stuff, but if you go back in '72, I mean, nobody knew what they had passed with Title IX. I mean, Nixon, there was no signing. Somebody said there's a signing ceremony and Nixon did a party or something. That never happened. But the immediate impact was, wow, this is going to impact college athletics. And so a lot of high-profile football coaches, Darrell Royal at the University of Texas, Bo Schembechler at Michigan, was like, we need to do something. We need to exempt revenue-generating sports. And that was pushed back specifically by Congress. And there was the Tower Amendment, which was defeated. And long story short, there was some guidance issued by the Department of Education. And there was one path they could have taken on athletics. They could have taken the path of, hey, Title IX prohibits sex discrimination, and so long as everybody can try out for the football team, then you're not violating Title IX. And yes, all the opportunities go to men. Too bad, so sad you had the opportunity to try out, you didn't make it. That's not the tact that was taken. What was taken was this, I mean, literally, if you read it, and I know this is anathema, but in that context, it's what applied, is separate but equal. We recognize that you need to have certain participation opportunities for men that need to be offset by specific participation opportunities for women. Men's basketball, women's basketball should have equal facilities, equal access to coaching. That's the way we interpret Title IX. And there is an interesting argument about, well, now you're kind of turning that logic completely on its head by saying, hey, I'm biologically male, but I can participate in female sports. So I just wanted to point that part of this out. I mean, in the 70s, and that was pretty radical, by the way, in the late 1970s. There's no corollary to a department approaching kind of an issue along those lines in the last 40 or 50 years. So it is significant in that regard.
I want to go ahead and throw it open to questions. I don't, yeah, there is somebody at the back mic.
Yeah, thank you so much for a great presentation. I have a very practical question about the Biden-Harris Title IX regulations, particularly in the context of transgender and sexual orientation issues. How should state colleges and universities, public institutions of higher education, proceed at this point, the Title IX offices? The regs have been pretty much put on hold by the courts. I've seen a lot of guidance from state AGs or state secretaries of education in the K through 12 context, but how should higher education proceed at this juncture?
I thought KC said something that was spot on. Most colleges, if not all, prohibit discrimination on the basis of obviously sex, but also sexual orientation and gender identity. By the way, some of that specifically because of a decision from the Supreme Court, the Obergefell. So there's some tie-in between Title IX and Title VII.
And Bostock, too.
Yeah, that's what I, yeah, exactly. So there's that piece of it. The question where it gets really thorny is around access to bathrooms, access to locker rooms, and access to athletics. On bathrooms, I think I work with a lot of big public state institutions, and I think for the most part, the way they've resolved it is, they have unisex bathrooms and things like that. Locker room access, I think most schools have largely, public institutions have punted. And I'm not aware of any big public university that has allowed a biologically male student athlete to participate in female sports, although there could be one. So I think it's clear that the prohibitions on discrimination apply. If I were to fire someone because they're gay, because they identify as trans, that's going to violate policy. Access to facilities has been sort of approached, I think, in an ambiguous fashion by most public universities.
And also keep in mind that there are blue states where this is mandated by state law in terms of equal access to facilities. And so, in part with the injunctions, they are this sort of red state, blue state divide already with the injunctions. In lots of blue states, the Biden-Harris, Title IX regulations on the gender identity side would have no impact because state law already was requiring the sorts of things that the regulations are offering.
Hi.
And I didn't see which of you got to the mic.
I
think back there.
Okay.
Yeah. Max Seaton, the American Enterprise Institute. I have a question on something that Candace kind of brought up in passing, right? So if President Trump is elected, it may well be the case that dogs and cats will be safer. But it's not clear to me that the DeVos regulation will be safer, right? Because if the Biden-Harris regulation gets dropped, the DeVos stands again, there's quite a distance between the words of Title IX and mandating that every college does due process in just such a way. And so how concerned should folks who care about due process, folks who supported that regulation, be that kind of Loper Bright provides an opening for that to get destroyed and possibly, even greater danger if the election goes that way?
I think it is of some concern. I really do. I think that for reasons, but the end result was that the 2020 regulations were very prescriptive on a topic, sexual harassment and assault, that appears nowhere in the statute. So I think there's some vulnerability there, and I think a lot of us for a while have thought, it's probably not realistic to put, the legislative horse back in the barn, but probably what's needed at some point is to turn this back over to Congress for some clarification.
I'm sorry, I had to laugh.
Well, I would like to take advantage of the opportunity to ask Carrie if she thinks that the demise of Chevron will create an incentive for Congress to get back to the task of legislating. I mean, I would have thought that one of the reasons, and maybe this isn't it, but one of the reasons Congress is so hesitant to legislate is we wrote this perfectly clear law called Title IX, and my God, look what happened. I mean,
Yes.
it must create some incentive not to legislate.
That's one of the reasons, and I think that is when people say, how do you fix this? And my response is, it says what it says. I don't know how things became so confused. It says what it says, but I do think, and in fact, I'm very well aware of the fact that we are looking at things that we can do congressionally in response to the Chevron decision. So there will be some action taken, and again, it's going to depend on what happens in this election as to whether we're successful in moving forward with that sooner rather than later.
Can I just say this too, because now you've got me all worked up. There's a conservative case against the 2020 regs, and it's really straightforward. It's number one, Title IX says nothing, and I think you just alluded to this. Now, this was challenged, and no court, I think, bought it. But
Under Chevron.
yeah, Title IX doesn't speak at all to due process rights for students, period, end of sentence. And so this was an exercise in agency rulemaking that is not moored in any way to the statute. The other I don't understand politics anymore. Back in my day, it was like the Republicans were the ones who said, no one-size-fits-all approach should apply to everybody, and Washington, D.C. shouldn't be dictating policy. The Title IX regs under the Trump administration flipped that on its head. So I thought the question was pretty interesting, what will happen next. I will also just say one other thing. There's an incentive to legislate, and there's a capability to legislate. I don't know if we're capable of legislating anymore. Like, I look at who really pushed Title IX, and it's a congressional rep by the name of Edith Green, who does not get the attention. She was a Republican. But what she was a savvy legislator who knew how to get things done and build consensus. And I don't know if we have that as much anymore. We have way too many legislators more interested in putting out hot takes on Twitter and X. So there, I'm done. I'm off my high horse. Thank you. Not you, of course.
Present company accepted.
Yes.
The front mic.
Sure. Thank you all so much for your time and the great discussion so far. I have a sort of a systemic or a structural question for anybody on the panel who feels comfortable answering. One theory of the case with Title IX is that, well, this is federal money, and so schools that accept this federal money, you take the bitter with the sweet, and if you don't want to deal with these regulations and the incumbent bad consequences for students and administration, you just tell the feds to pound sand and you don't take their money. But the other theory of the case is that's a practical impossibility for the vast majority of state and private schools. So I was just curious from the expertise on the panel, which end of the spectrum are we? Is it a practical impossibility for anybody except for the Harvards and Yales, or is it, with some belt tightening, more possible on a practical level than maybe it appears from the outside? Because that might determine how many of us feel about how much the government should be involved in these regulations in the first place. Thanks.
I would take that and I think that it would have been easier to reject the federal funding prior to Congress acting after the Supreme Court decision that said that the federal funding would be taken away from only that program. So the way that the Supreme Court had initially ruled, in what year was that, 1988? 84. The question was, if a school takes only federal fund, if there is a program, let's say it's the athletic program that's taking federal funding, if they discriminate, it would only be that program that would lose the federal funding, not the entire school. And Congress went in and changed that after the Supreme Court ruled and said, no, if you take any federal funding whatsoever, then you are subject to Title IX. And I know I'm not explaining that very well. Perhaps you can explain that a little bit better.
I mean, that was it. I mean, there were challenges. This was mostly in the context of athletics programs, where the NCAA was making the argument, the athletics departments don't get any federal financial funds. We shouldn't be governed by Title IX. And there was a Supreme Court case in 84 or 86 that said we agree. And then Congress came back and amended Title IX to say, no, it's if any part of the institution gets funds, the entire institution is covered. Look, I'll just, the practical question, I mean, Hillsdale, I don't think.
Hillsdale's the only one.
Yeah, it doesn't do, I mean, it's doable. I think the university, based in Austin, Texas, weird place. I think the new University of Austin is not taking federal funds. I mean, I'm sure there are ways to do it, but most of the institutions rely on participation in Title IV federal financial aid, I think is the answer.
That's probably the big one. And there probably is a difference in risk level for K through 12 versus higher ed, partly for that very reason. But as in the spending clause analysis of things, some of the provisions, I think, arguably require schools to start violating the Constitution. So in that situation, I don't think it's a fair choice that's being presented to institutions.
The other thing I would comment on, just with respect to Hillsdale College, which I know a little bit about because my daughter is a senior there, there's a lawsuit currently going against Hillsdale trying to force them to comply with Title IX as a condition of settlement, of the lawsuit. That's where the plaintiffs bar, and this is a very serious effort by one of the preeminent plaintiffs law firms in the country, trying to sort of force that. So it's not, even if you want to opt out for not taking federal funds, which Hillsdale and Grove City and maybe there's a couple others, that doesn't stop someone else from coming in and trying to force you to comply, even though you don't want to.
By the way, that case was Grove City versus Bell. That
Was-
you were, yeah, so
Okay.
well
Yeah.
done. Yes.
Thank you.
The back microphone?
Thank you. This is mostly directed toward Congressman Hageman, and if maybe you can answer, or anyone else certainly, and I want to build my two short questions on a quote of Malcolm Muggeridge, who was a journalist in the 20th century. I think that we have not only educated, but we have legislated and litigated ourselves into imbecility. Now, having said that, the comments earlier about most of the folks believe that men and women shouldn't be in the same sports because there are differences between the genders, and this is kind of off the topic of education, but do you see a bleed over effect that if women are arguing that it's going to raise an issue in terms of women in combat? And then the other one is do you see at all any chance in the future of the Department of Education being completely undone, or is it an industry that's just too big to fail and we're going to keep pumping money into it?
So as far as the combat issue, I see that is potentially an issue, but at the same time, what our various military divisions have said is that they have to meet the same qualifications. And we have historically not had women in combat. And one of the debates that we always have with the NDAA is whether women should be subject to the draft. And I'm opposed to that. I am opposed to that. I think that women serve with absolute distinction in our military, but it is a voluntary, it is a personal choice to make that decision. And I don't think that all women are capable of serving in that capacity. I think some women are fantastic, others are not. And so I do think that that's an important issue to look at, that is a matter of choice of what they're doing, that they're making the choice to go into the military. As far as your second question, it was about whether we would ever abolish the Federal Department of Education.
Yes.
I think that their budget is $80 billion. I mean, it's something so
If you don't count the student loan debt that's being
yeah.
unlawfully canceled.
That's exactly right, which was part of Obamacare. I've actually signed on to a bill to abolish the Federal Department of Education. And the reason that I have done that is because, again, going back to my history, I graduated from high school in 1981. I come from a long line of educators. I'm really the only one in my family who strayed. My mother, my grandmother, my aunts, my sisters, my sister-in-laws, everyone was an educator. My dad was a chairman of the education committee for the Wyoming legislature for decades. Education has always been incredibly important in my family, but when I was in school, we did have a Federal Department of Education. It was controlled and managed at the local level. And in Wyoming, I look at our history. Wyoming is the first state to give women the right to vote, 1868. 50 years prior to any other state, prior to the 19th Amendment. I have an annual from the University of Wyoming from, I think it's 1922. It's almost 50% women going to school at the University of Wyoming. Women have always had an incredibly important and part in governing in Wyoming. So I think I have somewhat of a different experience maybe than other places. And I'm always mystified as to why, with all of the discussion we have, so much of it centers around women kind of being victims in all of this, because we're not. And again, I think everybody understands what the purpose of Title IX was, and I think it's been totally distorted and become something else for political reasons. I don't know if there's the will to abolish the Federal Department of Education, but I think states are fully capable of handling education, and then Congress doing block grants is the way that I would prefer to have it done.
Thank you.
Go to the front mic, and this will be the last question.
Wow, thank you, Congresswoman, for those remarks. I'll do you one further. I would advocate a repeal of Title IX, and I think we don't discuss enough whether it was in fact ever needed. One question I wasn't going to ask, but since you raised it, is if you really think that you needed Title IX to get those programs when you were in high school, or wouldn't the culture and the atmosphere have been enough to give equal opportunity? I do wonder about that. There's stats showing that women were gaining in educational access well before 1972. But thank you to all the panelists for your interesting and important remarks. Casey, I was glad that you mentioned that the Duke lacrosse case didn't involve Title IX. You also mentioned that schools have these gender policies, most of them liberal gender policies, and of course you've brought up the blue states, which also have these gender protective laws. All of this quite independent of Title IX. So the question really is the problem Title IX, or is it the people running these schools and running these states, which for the remarks about the single investigator, that's the real problem, the people running the schools. And if any one of them becomes single investigators, you've got a problem. And on this point, the current Office for Civil Rights is enforcing Title IX with misgendering a Title IX offense, even before the Biden rule was released in April or took effect in August. That case was against Taft College in California. So they're actually enforcing a definition of sex that they're putting in the rule. So before the rule was even formally promulgated. So I see some bad faith, meaning that I think the problem is more the people.
We're about 2 or 3 questions there. Does anybody want to jump in on a piece of that?
Well, I think this ties into a point that Scott made about the single investigator model. It is true that the most procedurally protective approach is not going to be a defense against people who are operating in wholly bad faith or who have prejudged their opinion and vice versa. And certainly in the realm of Title IX, we've seen instances of this as a problem. I mean, one of the most infamous of these cases was at Amherst College, where a student who was clearly innocent was nonetheless found guilty and expelled. And it was factually it was just a bizarre case, but the key facts in the case were that the accuser was sending text messages during the alleged assault, complaining about how the fact that this student was not producing what she wanted, and so she actually arranged for another sexual liaison after the alleged assault. So these were as exculpatory text messages as you could get. And the investigator said, well, these text messages didn't matter because under her definition of Title IX, it would only matter once the complaining student had decided that she was sexually assaulted. Anything that she said before that would not be relevant. So in that kind of system, you could have the most procedural protections in the world, and it wouldn't matter if that's your decision maker. So yeah, I mean, I don't think that we want to either remove blame from people who haven't judged these things fairly. Yeah.
Can I maybe give each of you 30 seconds for final thoughts before we wrap up? Candace?
Sure, that was an interesting last question to wrap up on because I'll just put out there, I don't think that Title IX has outlived its usefulness. I think there's still reason to have it around. I think the statement and goal of equality between the sexes and what that means is still an open question for interpretation and application in our country. I think that the issues around gender identity have made it clear that what we need to do moving forward, whether it's executive branch agencies and or Congress, is realize that apparently right now in Western society we are not taking for granted the question of who are the men and who are the women. So we do need to restore that common sense in a formal legal way. And also, unlike when Title IX was originally passed in 1972, we do need to focus more on the rationales for the exceptions, because that's what we're really fighting over here on the gender identity stuff, is in the exceptions. Generally speaking, treat boys and girls equally in school, great. It's the exceptions. Separate out girls and boys when it comes to sports teams. Separate out girls and boys when it comes to giving them their own locker rooms, their own restrooms. So it's the exceptions that are the tricky areas, and so I think both legislatively and in regulations we need to focus on that and spell out the rationales why. There are basic sex differences that aren't discriminatory or stereotyped. They're just differences that require sometimes separate treatment of the sexes.
I'll go quick. I just think it's an interesting, and I won't even make a Title IX direct point. I think it's just an interesting time post Chevron, Loper Bright. I mean, and we see it playing itself out in the context of Title IX. That you have an agency that historically, hasn't issued regulations, but has done so here, and there is this reluctance of the federal judges to issue nationwide injunctions, and so you have this patchwork of approaches by different states, and it's just interesting to me to watch this unfold in an era where it screams for a legislative intervention in my mind, and I just don't think we're capable of legislating on these sorts of issues. So I think all of that's really fascinating.
And along those lines, if we project ahead, say a decade, think of all that's happened in this area over the past 10 years. So if we were all to come back here, God willing, 10 years from now, we would have no idea what would sort of be on the agenda. And that does scream out for legislative intervention, but I agree with Scott. I mean, we haven't seen much of a chance for this. And so given that, it's likely that we're going to continue to stumble along with this combination of education department intervention, but also the courts really as the bulwarks in terms of standing up against aggressive legislative executive action. One final thing. It may very well be that because they were so aggressive in including the gender identity provisions basically in every aspect of the regulations, that one effect of this Biden-Harris regulation will be to get this issue to the Supreme Court far earlier than it would have been the case, in which case, everything will then be on the table.
Harriet, we'll give you the last word.
I think that perhaps Title IX may be more important now in light of the political push to erase women. There are incredibly important distinctions between men and women, and especially when it comes to things like athletics and our personal spaces and those things and personal safety. And when there is an effort to erase that, me as a woman and me as someone who has granddaughters and nieces, and I want to preserve those protections. And I think that Title IX, saying what it does, should be interpreted to mean what it says and says what it means. And if that is what the Supreme Court does, I think ultimately that will benefit women.
Please join me in thanking our panelists.
Chart the future of Title IX. At this time, we ask that you all join us in the Grand Ballroom for a keynote address from Virginia Governor Glenn Youngkin. And please do your best to find your seats quickly as the governor's on a tight schedule, and lunch will be served after his remarks.